Hello. Item claim will be postponed to 17th, my lord. Connected matter is on that day. 7.
Counsel for the appellant is present at request posted to 17 level.
Yes.
Page number 23256. But item 14, 14. And I appear for the petitioner. And I request a week's time on it.
Notice is already served.
Yes, yes.
Counsel for the revision petitioner is present at request posted to
Already Lordship may have posted in the last week of this one.
4th December.
But the Lordship may extend the interim order. Lordship may extend the interim order. There is an interim order.
Interim order granted earlier is extended. We'll verify the interim order. And
Yes, yes. As on today, there is an order.
Item number 65. I am for the appellant.
Yes.
The appeal has become infructuous because the suit was already withdrawn. Against the interlocutory order, appeal has been filed.
Last one. Counsel for the appellant stated that the suit has the CMA has become infructuous. The suit is withdrawn.
Yes.
Suit is withdrawn. And summary of the submissions, the CMA is dismissed as withdrawn. As infructuous. Dismissed as infructuous.
My lord, CA is still for certain waiting matter. I love country and only.
2014,
18.
14 and 18 matters now.
It's first time.
First week number 5th. This week. Yes. CMA 130 of 2019. CMA is dismissed. CRP 1152 of 2014. CRP is dismissed. No cause.
Obliged.
My lords, I am appearing for the petitioner in the matter. My lords, I have instructions to withdraw the matter.
Yes. Permitted to withdraw.
Obliged.
Four and 5.
I am for the respondents in this case, Lordship.
I am appearing for the petitioner. Appellant, my lord.
Respondent.
Already
May please, your Lordship.
Why it is under the caption for orders?
Lord, every time respondent sought time, my lord, since your lordship.
That is okay. We have not posted it for orders, but when it is in the caption for orders in the cause list.
Yes, my lord, last occasion lordship posted for orders stating
No.
that no further time.
No.
For hearing, you give a time for me, Lordship, in this.
24/7. మీరు చాలా మారుస్తున్నారమ్మా. ఒక పేజ్ టర్న్ అవ్వగానే ఎట్లా మారిపోతూ ఉంటుంది చెప్పండి. ఇక్కడ ఫర్ ఆర్డర్స్ ఉందా? ఇదిగో 11:10 ఫర్ ఆర్డర్స్ ఉందా? నెక్స్ట్ పేజ్ టర్న్ అవ్వగానే మళ్ళీ బోత్ కౌన్సిలర్ ప్రెసెంట్ అన్నట్లా.
On that day, I requested Lordship, I want to argue the matter, kindly have it one date. And yeah,
Anyway, you submit your arguments.
Lordship, I am for the respondent number 1 and 2 in this case, Lordship, diseased Samaya. Respondent 1 and 2 have filed an application before the authorities under Workman Compensation Act to paying the compensation for the death of the deceased Samaya. And the same was numbered as a WC number 3 of 2010 and passed an order in the lower court, Lordship, on 26/6/2013, Lordship. Brief facts is, Lordship, the deceased Samaya discharged his services to the petitioner's company 30 years, Lordship. He worked as a plumbing man as 30 years, Lordship. In the time of the plumbing work, while discharging services, developed chest pain, Lordship. The petitioners never taken immediately to the hospital. His son came and taken the hospital, and on the same day he will be taking undergoing the treatment. He died, Lordship. Due to the negligence of the petitioner Samaya is died, Lordship. It is proved in the lower court also, Lordship. Death occurred in the course of the employment and out of the employment, Lordship. There is a clear cut the opposite parties did negligence, Lordship. As such, petitioners are liable to be paid the compensation. The lower court also decided the compensation amount. Dragging the matter, they will be filed the CMA. There is no other thought, Lordship. The petitioners, instead implementing the lower court award, preferred an appeal, dragging the matter, which is highly unjustifiable, Lordship. Therefore, I pray Honorable Court uphold the order of the lower court in the interest of justice, Lordship. It is the accident that occurred in the time of the working time only, Lordship. Office working hours only. They will be not shifted immediately to the hospital. If they will shift immediately hospital, he is survived. But his son came and shifted the hospital. Lower court also taken a lengthy trial, Lordship, conducted lengthy trial and awarded the compensation amount, Lordship. Kindly go pass on the lower court award with the interest, Lordship.
Yes. Counsel for the.
May I submit, Miller, the contention that we have neglected while taking to him the hospital is not correct, Miller. Your Lordship may kindly see the reply.
Madam, switch on your video, please. I can't see you.
I'm sorry. Your Lordship, at page 25, Millard, reply has been given by me, Millard. Page 25, Millard.
Yes.
Millard, while he was on duty, Millard, on 3rd August 2009, Millard, technical staff, Millard, noticed that the deceased was sitting on the bund. On inquiry, Millard, by the technical person, it is known he was having the burning sensation in the chest. Due to acidity problem, he has informed. Millard, immediately he has shifted to the Crisat Hospital, Millard. Your Lordship may kindly say, along with the wife and son, who are also employees of the
Same company.
appellant. Immediately has shifted, Millard. Then on verification, Millard, they will not get any medical reimbursement. On their own, they are shifted to another hospital. There he died, Millard. The contention that we have neglected to shift him to hospital is completely wrong, Millard. Your Lordship has stated so. Only Your Lordship may kindly see the finding of the lower court order, Millard, except saying that he is an employee. Nothing has been elicited from the evidence, Millard. Your Lordship may kindly see at page 7 of the para 9 of the order of the lower court. From the bottom, Millard, about 9 or 10 lines, Millard, the above, Your Lordship got it, Millard? Page 7.
Yes.
From the bottom, Millard, about the above documents.
Yes, got it, got it.
Above documents and the letters produced by the opposite parties clearly prove that the deceased was an employee of the opposite parties and that he died while on duty. Therefore, there is no dispute regarding the employment of the deceased. Except this, my lord, there is no averment that due to accident he has died or from under section 3 of the act, my lord, there must be some occupational disease or some connection to the work he is working, my lord, at the employment. That is not the case here, my lord. Your lordship may kindly consider that aspect. He died due to heart attack. There are so many reasons, my lord, for getting heart attack, my lord. With regard to this, my lord, I have already furnished the copy of the judgment of the Honorable Supreme Court, my lord. Jyoti Adema versus Plant Engineer Nellore, my lord. Your lordship may kindly
I
consider
should
that.
go through my written arguments in lower
Under-
court and my counter
Under,
also.
your lordship may kindly say phase 2. Phase 2 of the judgment, my lord.
1 minute, madam.
He is company worker at 30 years, lordship, not a single year. He is doing the plumbing work only, in the same company. Already lengthy trial is conducted in the lower court also, lordship.
Yes, ma'am.
My lord, section 3 has been incorporated in the judgment, my lord. Your lordship kindly say phase 2 of the judgment, my lord.
Yes.
Section 3, employer's liability for compensation. If personal injury is caused to a workman by accident arising out of and in the course of his employment, his employer shall be liable to pay compensation in accordance with the provisions of this chapter, provided that the employer shall not be so liable in respect of any injury which does not result in the total or partial disablement of the workman for a period exceeding 3 days. In respect of any injury not resulting in death or permanent total disablement caused by an accident which is directly attributable, the workman having been at the time thereof and the influence of drink or drugs or the willful disobedience of the workman to an order expressly given or to a rule expressly framed for the purpose of securing the safety of workmen. Miller, under section 3(1), it has to be established that there was some casual connection between the death of the workman and his employment. If the workman dies a natural result of the disease which he was suffering or while suffering from a particular disease, he dies of that disease as a result of wear and tear of the employment, no liability would be fixed upon the employer. But if the employment is a contributory cause or has accelerated the death, or if the death was due not only to the disease but also the disease coupled with the employment, then it can be said that the death arose out of the employment and the employer would be liable. Admittedly, in this case, Miller, there is no connection to the death, Miller, to his employment. There is no finding of the lower court also, Miller, you will may kindly see. Therefore, Miller, section 3 does not attract to the facts of this case. Miller is not entitled for any compensation.
Reserve.
Miller, so far as other case is concerned, Miller, they
You're not
impose the lower court imposed a penalty, Miller, not paying the amounts, Miller, within time. Your lordship may kindly see last occasion I draw your lordship's attention, Miller, at page 3.
308. 308 of 2014, item number 5.
Item number 4 and 5 are connected together.
In connected matters.
And is it a common judgment or not?
Yes,
No?
yes, yes.
Common,
Miller.
huh? Okay.
Miller, this just
That we have judgments, madam, regarding penalty.
Miller penalty. There are
We have
judgments.
dealt with those issues
I will
earlier.
bring to your lordship's only dates of the orders, Miller. That is
Okay.
only my complaint. Your lordship may kindly see at page 3.
308. 308.
Pardon, Miller?
Yes. Page
Miller, your
number?
lordship may kindly take the page 3.
Page. Hmm.
Page 3 of my appeal. Your lordship may kindly see the date of the order. It next page. Internal page 2, Miller. My page is page 4. 30th January 2013. This is the order passed. Your lordship may kindly see the application filed by the petitioner on next page, Miller, page 7. Kindly make a note, Miller, your lordship may kindly see. 8th May 2013. And the learned judge says, Miller, This application is filed on so and so 21. Order is 30th January 2013 Millard for imposing penalty. Application filed on 8th May 2013. And at page 9, show cause notice issued Millard on 4/6/2013. Lordship, can say page 9. 4/6/2013 show cause notice. 14/5/2013 application. Order of 30th January 2013. Even before issuing show cause notice is imposed a penalty. Millard, it is an institute, Millard. Head of the institute is situated at Delhi, Millard. Therefore, they cannot get the orders from the hierarchy, Millard, to deposit the amount. That was the reason, Millard, for delaying the depositing the amount. At the time of filing appeal, we have already deposited. Therefore, your Lordship may kindly consider this, Millard,
Yes.
to satisfying the orders of the lower court, Millard.
Lordship, my prayer is only conclusion that death in out of the employment and in of the employment only. Lordship, kindly allow the prayer in lower court prayer and pass on the orders on merits, Lordship.
Yes.
Both are connected matters.
Both are resumed.
Obliged.
Next.
6.
In this case, my lord, I sent notice to the respondent, my lord, but the same was returned with endorsement that petitioner address is out of village. I sent the notice through my colleague, my lord. He may be not there, my lord. I am appearing through virtual. I sent the file through my colleague is there.
Notice not served.
Notice is served.
Not served.
Not served. What is the reason?
I am representing of Address with
Address is left, my lord. The notice endorsement.
Address is left.
Address out of village.
Want to-
Out of village.
Will you file the substitute service petition then?
Fresh notice may be ordered, my lord. So that same address he is living in the same village.
Yeah.
Address is the out of village, my lord. Just only out of village for that particular days.
Okay. Issue fresh notice to respondent. To court CRP. So notice is also permitted.
Oblige, your lordship.
Post 30/11. 30/11.
Please, your lordship. Then before your lordship are defended 1, 2, and 3, my lord, the appeal is filed against the judgment and decree directing the defendant 1 to 3 to pay amount of 16,60,000 along with interest from date of MOU. Now, generally, this court, in all money decrees, granting 50% stay on payment of 50%. But in this matter, my rescue submission is I am ready to deposit 25%. The reason is that the plaintiff filed suit in the year 2013 claiming interest from the year 2006. The court also granted interest from 2006. He did not pay the court fee also. The lordship very well knows that whenever plaintiff files a suit, he has to file suit on the date of filing of the suit. The lordship kindly see the decree granted that page 80, 19 minutes. The result suit is decreed with cost for an amount of rupees 16,60,000 and subsequent interest at 6% per annum from date of MOU. But suit was the date of MOU is 4/7/2006. But suit was filed in year 2013. And he did not pay court fee. How can he claim interest on that? That is my submission. For grant of pay, you are I'm ready to deposit 25% of the appeal amount. The MOU, your lordship, can you see the MOU as page 23, minute? The lordship, can you see the date of MOU? 4th July 2006. And here, where the suit is filed.
In this matter, notice is not yet sent.
No,
Not sent. Coming. And it is an interlocutory.
I filed IA for
Stay.
grant of stay.
Sir, Issue notice to the rest.
I'll take personal.
Yes, as personal notice also permitted.
Okay.
Let me give the date also for notice. 8/12. No, actually 2 weeks since I put not 2 weeks. Yes.
Okay.
Lordships, I am for the respondent. Okay, wait petition filed, your lordships. I have received the file.
You are for the respondent.
So the appellant,
Hmm.
present
What is the IA?
suspension of the order of the court below minutes, money recovery suit filed with up in year 2014, basing on a promissory note,
Hmm.
alleging that not the petitioner herein received an amount of 10 lakhs towards hand loan.
Hmm.
And the same was denied, saying that no such amounts were received by the plaintiff. Paid by the plaintiff. Lordship may entire evidence led by them in the it is where the witnesses also said so blood only is a stranger to the defendant in the suit. He was not recognized. He says that blood I was present at the time of handing over the amount, but he failed to say that so who is the defendant. And only basing on a promissory note, the entire suit was decreed. Seeking the suspension.
Yes.
Lordships, may I please permit your lordships? Whereas the stand taken by appellant defendant that said a promissory note was forged and fabricated. But they did not try to elicit that it is a forged and fabricated document for filing a petition before the trial court for a comparison of signature of appellant was forged. Whereas the suit was filed by the respondent plaintiff in the year 2014, the same was decreed in the 2023. During the 9 years of period, there was not taken any single step for trying to prove that the forged document is forged and fabricated. Money license without holding, they raised another allegation in the petition, your lordships. The respondent plaintiff in the cross-examination of DW1, that PW1 clearly admitted that the cases were related to the respondent plaintiff firm cases, not individual, though the money lenders act does not applicable. And your lordships, in the main index, your lordship, they have filed a copy of chief examination of DW1, but they did not file the exhibits and PW1 depositions also. And again, the appellant defendant did not elicit that the plaintiff respondent did not holding money lending license and giving loans to a third party. The same was discussed by the trial court in the decree, lordships, entire decree. The trial court rightly appreciated that the evidence available on record and decreed the suit in favor of the respondent plaintiff. The cross-examination of PW1 clearly admitted. Even the suit is pending, the plaintiff respond clearly the dates, clear the dates before the chit fund of appellant. He also admitted, your lordships. The transaction is January, but the allegations they are making is different transactions, not the suit transaction, your lordships. Prior to filing the suit, there is a business relationship, your lordships, not friendly relations or not, but there is a business relations also were there. The plea taken by the appellant did not appreciate the fraud plea of defendant, your lordship, by the lower court. The appellant, as I said, your lordship, the appellant did not file cross-examination of DW1, did not came with clean hands before this honorable court.
See, I'm not going to the main suit, okay? Suspension petition, we are taking up suspension petition, argue on that.
Lordships kindly grant 50% of total decretal amount, then suspension petition may be allowed, your Lordships.
I may say one thing. The main contention of the plaintiff in the before the court below is that, my lord, he has not received any amount. With that, my lord, he also categorically stated that, my lord, denied the execution of it. Who is the plaintiff who approached the court, my lord, it is for him to prove that case that he has executed, he has got executed in.
But the suit is already decreed.
It's a first appeal. So you actually so give us like 25% amount will be granted because it's a straight away money suit. my lord.
Come. There's a condon delay petition is there, sir.
Yes, 2 days, only 2 days there is there.
Hmm?
2 days happened.
But 2 days also, but we have to issue notice now. In filing the appeal only, issue notice to the respondent.
This petition is in process.
Hmm.
I mean, permitted to take a personal notice.
Personal notice is permitted. I'll post it for a short date, okay?
What?
24. 24 left.
Millards, for appellants in this matter, Millards, in the last occasion, having for condoned delay, Millards, when the respondents informed they'll be filing.
Who is the other side? Counsel is here. You're representing the appellant only, no?
8 minutes.
And petitioner in 2 of 2018. For 8 minutes. No representation for the respondent and call counsel for the appellant is present. But filing counter, if any, in IA 2 of 2018 posted to 29 level.
Obligement.
Worship, request for 2 weeks, VP will up in order for the content matter.
Finally, for respondent.
Hmm.
And the last actually just put this slip waiver out. This is long 20 cases, it's almost like 3 decades, 4 years. How to either sleep for adjustment because some possibly 80 what deposit the complete amount, but they are not deposit. They have deposited only the 95%, they have not deposited the 5%. So how else we can just go to the final million clearly. There is a multiple cases, large periods. There is a still number 11 at 12 as well. The last occasion also they just keep on sitting with them, so I didn't comment on this.
What is this memo filed? Yes, sir. You have filed. No, memo.
It's a calculation.
Where's memo?
Just file a calculation.
No, it is USR number 29229.
I'm not really sure about it.
Looks like memo is around. It is for received documents. You have to file an application under order 41 rule 27. Who has filed this memo? You have to file a petition for additional documents.
Which yes.
You have to file an application under order 41 rule 27 for additional documents. If we wanted to file documents, simply filing memo is not sufficient.
Yeah, just file proof of change.
No.
Extension, not just file. Whereas we are discussing about the ECB number 11, it's a CRP 654. Yeah, serial number 11. It's 5.
Don't get confused, concept.
No, both are connected.
Wait, let's see.
No, 12 and 13.
Okay, 12 and 13.
Yes, 12 and 13.
12 and 13.
Both the CRPs are filed by the GP for arbitration only. Then why you have filed a memo for received documents?
I just filed through memo, so I just filed.
You should have filed through memo.
Because it was an urgency, so I didn't, I was filed through memo.
Anyways, the GP for arbitration is not ready. I will adjourn the matter. In the meantime, you can file an application to receive the documents.
There is no extension in this lordship. Already this
One observed for presidential extension. Will. Presidential. His interim stay is there. Stays there. Item 12 and 13. Both counsel are present at request of the GP for arbitration posted to 6/12.
item note 6,
6.
there is an.
12.
There is a space for ask them to pay the complete amount, kindly direct them to pay the complete amount, because they just paid only 50% mark.
6/12 will dispose of the main CRP. In the meantime, you file an application to receive the documents.
Right, I agree. So,
6/12. How many adjournments they have taken? Okay. No representation. Item number 15. You are representing for the revision petitioner. Have you are the counsel filed IA 2 of 23 condon delay petition. 3 applications.
IA1 is for
This petition is okay.
Yes.
2
is
of
for
23. Have they filed counter in IA 2 of 20?
I am for the petition.
No. Other side counsel have filed counter.
Let me
They
call.
have not filed counter. We'll give an opportunity for them. Because no representation for the respondent called. Counsel for the revision petition is present. For filing counters, if any, in IA, posted to 6/12. Is there interim order? Order is granted. Earlier is extended till that. 6/12.
Applying for respondent in this matter, my lord, request 1 week time.
And for the
Revision petitioner. Both counsel are present at request of the counsel for the respondent posted to 7/12. Yes.
Leadership, I'm appearing on behalf of the respondent counsel.
Okay.
He's stuck up in another court, madam. Question for a passover.
Instead of passover, document, take it up on market. Please that.
Are your counsel is ready with the arguments today?
I was told he was reasonable.
If he's ready, I'll pass over. Otherwise, I'll adjourn the matter. No counter thing?
We have formal copy, the penalty by
So are you going to file counters?
Sure, we will file.
Both counsel are present. Posted to 23 matter. Now I'll adjourn to 7/12.
Obligation, that's about that. That's short paper. Because I'm ready with the matter. Or any.
23 matter. What is the urgency, counsel? What is the urgency?
Petition has been filed by the petitioner order 3825. That application has been.
Before the trial court.
Yes, ma'am.
What happened?
That will discussed by the trial court. But the objection now is knows that the first respondent who is the dependent in the suit is an employee in the Singarani company. But now he is going to retire. If the retirement amounts are paid, security will not be there.
Trial has commenced in this case?
Yes, trial.
Trial has commenced?
Trial is yet to commence.
No, not yet. Okay.
Since there is a, unless you retire and you get the benefits, that's the reason I'm asking for a short date.
When is the matter posted in the trial court?
So that.
You're not aware. You have to at least, based on that, I would have.
Sorry.
It is 23 matter now. Okay, 30/11. 30/11.
Obliged.
I beg to represent Mr. Harshan.
Yes.
The petitioners are the defendants in the suit. suit is filed for permanent injunction.
Hmm.
The trial court refused to grant injunction
Hmm.
and the appellate court reversed that finding and granted injunction.
Hmm.
The trial court, my lord, went into the title
Hmm.
and found that they have not established title. The trial court judgment starts at page number 17. Page 21, point number, para 6, minute.
Hmm.
May I read, minute?
Yes.
Pardon?
Yes, yes.
As seen from the averments of the petition and counter, there is no dispute regarding present possession of petition scheduled property is with petitioners or his father, but the claim of the petitioners on the basis on which they entered into possession of the petition is in dispute. As per the version of the petitioners, their father purchased the petition scheduled property from respondent number 1 under simple sale deed. Admittedly, simple sale deed on which petitioners claimed their father purchased petition scheduled property was not seen the daylight of the day. However, petitioner filed 13B certificate, and on bare reading of the said document, it reveals that Uchaya, that is respondent number 1, purchased land from petitioners, that is K. Rajanna, which is not the case of the petitioners. As such, the said document 13B certificate is against own case of the petitioner. Though petitioner further relied on mutation proceedings so and so, but it reflects on basis on which the said proceedings were issued was 13B certificate as mentioned supra. The mutation proceedings were issued against the contents of 13B certificate. As such, both the said documents are not helpful to the petitioner to establish that petitioner's father Rajanna purchased petition scheduled property from respondent number 1. As per the version of petitioners, petitioner's father purchased petition scheduled properties on 24/2/1990 under simple sale deed from respondent number 1. But as stated supra, no such document is filed before the court. Further, same was not reflected neither in 13B certificate nor in mutation proceedings of 13/1 4. As such, the basis on which petitioners claimed right through and their father was not been established with cogent evidence. Apart from that, petitioner claimed rights over the property under registered gift settlement deed, but as stated supra, donor, that is father of the petitioners, do not possess any valid title as per the document relied by them, except the revenue entries which were admittedly altered in the year 2007 and 8 Pahani. As such, though documents appear to be in favor of petition, but the same are suspicious in nature and basis for which alteration was not being placed before the court. As stated supra, at the inception, there is no dispute that petitioners or their father are in possession of petition scheduled property, but the claim of equitable relief as claimed by the petitioner has to be looked into on the basis of equity. Respondents categorically contended that respondent number 1 never sold such property either to petitioner's father or to anyone, and on that claim, revenue proceedings were taken up under appeal before the RDO, and the same was made over to special tribunal constituted under the latest enactment of Telangana Rights in Land and Patadar Passbooks Act. Though respondents in their counter categorically mentioned that initially special tribunal has allowed the appeal by cancelling the proceedings in the name of petitioners and his father and directed to register the name of respondent number 1 in the revenue records. However, in view of the orders of the Honorable High Court in WP number so and so against the said revenue appeal was reheard by the special tribunal, wherein petitioners placed document for pendency of this case, which is subsequent to the filing of revenue appeal, and on that basis, special tribunal has dismissed the appeal, directing both parties to redress their grievance before civil courts in view of pendency of this case. Thus, it has been impliedly stated by the special tribunal that title is yet to be decided by the court. However, it is also otherwise mentioned that revenue entries in the name of either petitioner or petitioner's father are kept intact with revenue records. But the observation regarding redressal of respondent number 1 grievance before the revenue tribunal were dismissed on the ground of pendency of this case as sub judice. As such, the title of the petitioner is still under cloud. Further, respondents contended that suit of the plaintiff is not maintainable in view of judgment number so and so. As such, the present petition is not maintainable and is prayed for dismissal of the petition. However, on perusal of record and judgment relied upon by respondents, the contention raised by the respondent that maintainability of the suit basing on the judgment relied upon by him cannot be decided under the present petition. As such, the petition.
आप देते हैं नहीं देते पाकिस्तान को करो तैयार
ఏంటి అవుతుంది అక్కడ?
बता रहे नहीं बता रहे
Counsel, please switch on your video.
ऐसी तरह क्या भी चीज का
Yes. Is the disturbance from your side?
No, no, no. I'm only alone in my chamber.
Yes, yes, sir. Yes, proceed.
As such, as petitioner failed to whisper about the filing of the petition before the special tribunal, and the same was disposed of at the first instance in his pleadings, which is a crucial one. As such, it amounts to suppression of material fact before the court. It is settled law that whoever approached the court suppressing the material facts, and the same amounts to approaching the court with unclean hand. Therefore, whoever approached the court with unclean hands are not entitled for any equitable relief of injunction. As such, this court holds that petitions are not entitled for any injunction as prayed for. So, Millet, the finding of the trial court is that the claim of the petitioner that their father purchased the property and their father gifted the property in their favor. They could not produce any document to show that their father purchased this property. So, since Millet, and so therefore, prima facie case is very important for grant of an injunction. So, therefore, Millet, on that ground, when they fail to show the prima facie case, the trial court dismisses the injunction application. So, Millet, when the respondent raised a dispute with regard to title, then petitioners filed suit for declaration and possession. So, now the appellate court granted injunction, reversal the findings of the trial court that starts at page 6. Relevant para 12. It is well settled principle of law that a person who is in possession of an immovable property shall not be evicted otherwise than due process of law. Accordingly, respond number 1 filed OS number 90 of 2021 against the petitioner here. Now, the said suit is pending before the trial court resolves. Respond number 1 herein is the owner of the suit scheduled properties and entitled for declaration of title and recovery of possession over the suit scheduled. Thus, petitioners established what the tribal issues with respond. Accordingly, they have established prima facie case, and if the petitions are disposed handedly without following due process of law, it will infringe their legal right. As such, balance of convenience in favor of the petition to seek interim injunction. The petitions are established irreparable loss if injunction is not granted. So, because now the respondents have raised a dispute, we filed a suit for declaration of title and recovery of possession. But this is not a suit filed by the respondents under section 6 of the specific relief act. Rightly or wrongly, we are in possession. We should not be dispossessed without due process of law is not their case. They have set up a title and said they are the owners of the property.
Yes.
In that context, the trial court said they have failed to make out a prima facie case. They have not established their title. So therefore, they are not entitled for injunction. But what the appellate court says is, you have filed a suit for declaration and recovery of possession. Therefore, they are entitled for injunction. They are prima facie case. This cannot be the approach. If they have filed suit under section 6 of the specific relief act, right or wrong, we are in possession, we are entitled for a relief of injunction. That is not the case here.
Yes.
Simply because we filed a suit, because we are liability citizens, we filed suit for declaration and recovery of possession. That does not mean that the respondents are automatically entitled for injunction. That's my submission.
Issue notice to the respondents.
Lakshmi also permit personal notice.
Personal notice is permitted. I am posting to shorter date only 28/11, sir.
I'm obliged. I'm obliged.
Next.
The respondent, Representative P. Rashid.
R4 and R5.
Yes.
Counsel for R4 and R5 is present. No representation for the appellant and GP for arbitration. No representation for the appellant. Constitute. 1st December.
I'm appearing the respondent.
2 weeks time. Both counsel are present.
My lord, I am appearing for the appellant, my lord. In this case, my lord, there is an interlocutory application. Probably that was the reason it's coming in interlocutory. Your lordships may post it for final hearing in the next week.
No IS are pending in this matter?
Yes, well, I am appearing for the appellate, my lord. I filed an interlocutory application.
Additional, what is this additional petition, sir?
Additional affidavit, my lord. Actually, I put it some additional evidence in this case, my lord. For the acceptance of for your lordships to be ordered these additional evidence, my lord, probably that was the point on which earlier also it has come. This can be heard along with the main
I'll post it for final hearing only. Both counsel are present. Rest is directed to post the CMA under the caption for final hearing. Is it an arbitration appeal, sir?
No, it is a endowment appeal.
Endowment.
Civil miscellaneous appeal. Actually, GP for arbitration appears in this case.
6/12.
6/12, my lord.
Yes, 6/12.
Lord, in this matter, I am for the appellant, my lord. I have to take steps against respondent number 2, 3, and 5. Lord, lordships may grant because notices sent to them were returned unserved. Lord, actually, I had requested this last occasion, my lord. Unfortunately, missed somehow, my lord. Lordships may grant some time. I'll file an application.
Actually, in the last occasion also a requested time, it is reflecting on the proceeding sheet.
I'm sorry, my lord.
Substitute service for petition.
I'll file an application, my lord. It's skipped out of my mind.
Okay. At request for filing substitute service. Posted to 20/11.
I'm obliged.
You file the application and
I'll file it, Lord. I'll definitely.
Yes.
I'm NR Prasad, my lord. I'm replying.
Very Prasad, respondent.
Ashok Kumar sir is there.
Respondent 2, 5, 7, 8 are different. Okay.
Yes, sir, number. Yes, sir, number. Memo is.
Yes, sir, number 1 number. Second number.
It is not found, sir.
Yes, sir, data of fund. Out of 22 respondent, 2, 5, 6, 7, 8 are unclaimed. Sorry.
No, just 2, 5.
2, 5, 6, 7, 8.
2, 5, 6, 7, 8. Unclaimed means deemed service.
Respondent 10 is concerned. Is by
Hari Prasad Garu is there.
the other respondents.
22/47 not necessary.
The respondent, sir. The Mr. Post letter was returned. Take steps for other respondents.
Yes. Notices to respondent 2, 5, 6, 7, 8 are rejected. Is rejected. They have refused. Unclaimed. Unclaimed. Hence it is. Hence deemed service. A USR number. Please note down. We'll note down the USR number also.
USR number 107 831.
Is filed 2, 5, 6, 7, 8 unclaimed, hence deemed service. for other respondents, 22 to 47, 8, 9, 10 kada, 11 to 22 not yet returned. From 11 to 47. Shall I issue fresh notice or any substitute service? So it's better, I think. You can't get the addresses also.
But also not some.
Issue fresh notice to respondents. 11 to 47.
Respondents.
To photo. Restricted. Karimnagar. 512, sir. 512.
512. Hold on.
Just like in partitions, they find community questions. Finally, they find again to appoint spending cards. Most of the
Why you have preferred the appeal in this case?
not what the respondent to fight final degree question.
You are the appellant or the respondent at present?
Yeah, absolutely.
That's what I'm asking.
Yes.
Why the appeal has been preferred?
Not final degree question. Super part of the.
Yes, final decree and
Yes.
advocate commissioner was appointed. He has filed a report.
Suit was declared.
I understood, sir.
Yes, the advocate commission appointed.
Mm.
But they were the land was property. Decided that they changed your. So much matter of that. Yes, advocate lower court is advocate commission appointed.
You say you are an appellant herein.
Yes.
And you say I have not preferred the appeal.
I prefer the appeal in
That is what.
Yes.
That is what.
This disposal of the range matter.
Let me see the grounds.
The order is there.
Let me see the grounds. Yeah, for the plaintiff, first plaintiff, I guess. Because suit is dismissed against the first plaintiff regarding the share. Also, 2 of 2021 is filed by the appellant or the respondent?
Appellate reports.
2 of 21, review petition.
Review petition because respondent getting
Filed by the respondent.
Yes.
No representation for the respondent on call. Syed Arshad Ahmad.
40%.
No representation. For the respondent and counsel for the appellant is present. Thanks, posted. 712.
Okay.
First again, the orders passed by the journal decisions, this is a specific performance of contract. I filed the appeal and a stay was granted me. They are contending that they paid the amount and we have not received the amount. They filed the matter may be extended. I want to file the reply after to the counter filed by them in the stay order.
Is there any IA 1 of 23?
Extension of our interim order.
No, that is 2 of 23. 2 of 23. In another quote, in IA 1 of 23, learned counsel for the respondent reported that they are filing the counter before the registry. What is that IA?
That will vacate orders.
They will file reply. Interim orders granted. Yes,
In other court.
in other court, not before our court. Yes, Amma.
In the, I'm for respondent, ma'am. It's coming for our argument, so see time, 2 weeks of time.
Anyway, stays extended from time to time. Then why you have again filed an extension petition?
If the matter is not posted, then I will be.
Safe side you have filed. Yeah, both counsel are present. At request of the counsel for the appellant posted to 7/12. The stay granted earlier is extended till 7/12.
Copy by tomorrow.
Yes.
My lord, appellant shop is anticipated requested 4 weeks time, my lord. Some difficulty.
What happened? Anthony Reddy garu?
Requested 4 weeks time, my lord.
4 weeks time. IAs are pending. 3 of 20.
Yes, ma'am.
A petition
Two IAs are pending.
to declare major declaration petitions have been filed.
That can be ordered, madam.
AS is filed. AS. Suit is for?
I'm not aware.
You should at least hold the file before representing.
I'm paying for second respondent. Madam. Suit is for declaration and injunction. Declaration was rejected, injunction was granted. Against the injunction granted, they filed an appeal. Defendants filed an appeal. Against the rejection of declaration, cross appeal was filed by the plaintiff. That is item number 26.
Yeah. Both counsel are present at request of the counsel for appellant. Appellant in 25, item 25. Posted to.
In next matter, in one IA is there, not cross appeal. That can be ordered because only permission order, rule 32 petition. GPA, it is being represented through GPA. That petition
That can be allowed.
That can be
GPA can be allowed. Is the permission IA 1 of 2023 will allow GPA. It's a ribbon. 1 of 20. Give it. Let me see.
IA 1 of 23 in is cross objection 54.
My IA 1 of 23 is. Okay, you are not aware. You are not even holding the record, counsel. Next time, don't do that. Okay.
Pardon, madam.
And post it to. Shall I post it to 7/12, 7 or 8? 812.
Oblige.
812.
Pardon, my lord.
812, both the matters. Objection.
Your Lordship, I am for the appellant. Kindly permit us to take out fresh notice, Your Lordship. It's not returned.
When we have issue notice to respondent on 1710. Proof of service not for notice sent for R1 not yet returned.
2 weeks time will be granted, Your Lordship.
Issue fresh notice to respondents 1 and 2 through court order.
Keep your pleasure, Your Lordship.
Posted to 112.
Keep your pleasure.
No representation either side on call. Hence posted to 7. Well. Notices, verified the notices R1 answer, R2 answer. Answered, answer insufficient address. Issue notice. Give that address, let me see. Let us verify and compare. The address which is mentioned on the poster is the same address. We have to verify whether the same address is. But that is R1, na? R1 is A. Sudhakar Reddy, Sri Ayyappa Reddy, house number 151405. Urmaya, son of Chennaya, 20 years ex-cleaner. It is not sufficient yet. Issue fresh notice to respondents 1 and 2 to correct address. Straight to 8-1.
My lord, I appear for K. Prabhakar in this matter, my lord. My lord, the sole appellant died. My lord, we have taken, our office has taken a notice to him. And to LRs, my lord, yet to contact them.
Last occasion also, 2-3
Yes,
occasions.
I do agree. Legal errors, my lord, it's already abated, my lord.
On 18/8/23, you have represented.
The legal errors have not contacted us.
What time for taking something not super. Representation respondent. Last comment. Counsel for the appellant is present. Though the learned counsel for the appellant stated that the sole appellant died, but despite opportunity has not taken steps. Hence, the CMA is dismissed as abated.
And permit us, if they can permit us file the application. It's already abated, my lord. The practice they come again.
Okay. You're at liberty anytime. You can file set aside petition with condone delay.
Much all.
I'm for the appellant. I'm for the appellant.
Yes.
The CMA is filed challenging the order under the Workmen's Compensation Act, Your Lordship, directing the appellant to pay compensation to the respondent, Your Lordship.
You are submitting arguments.
Yes, Your Lordship.
Oh, you are ready. But who is the other side, Amma? Mohammed Gauss. Mohammed Gauss. Okay, you submit, I'll put it as part heard.
Okay. Lordship, facts of the case are like this, Your Lordship. The respondent was employed.
Use the mic, switch on the mic and use.
Your Lordship, the respondent was employed in with the appellant, Your Lordship, as an assistant lift operator, Your Lordship. His scope of work is only with respect to operation and maintenance of the said lift and escalator, Your Lordship. On the date of the day on 6/8/2006, Your Lordship, after his shift ended at 8 a.m. in the morning, the respondent was relieved from the duty. He left from the premises, came back at around after 15 to 20 minutes, and then he slipped and fell on his own account, Your Lordship. It's an admitted fact that he slipped and fell on his own account. And immediately, Your Lordship, the respondent authorities took him to the hospital. For the medical treatment, the appellant paid for the medical treatment and for the surgery, Your Lordship. He took a leave of absence about for 60 days, Your Lordship, and then rejoined the duty and continued to work without any difficulty, and was late with full benefits, no reduction of pay, and was later promoted also as Your Lordship, as a senior assistant, Your Lordship. Now, the respondent has sought compensation under the Workmen's Compensation Act, Your Lordship, alleging that a slip and fell happened during the course of the employment, Your Lordship.
Yes.
Your Lordship, it's under Section 3 of the Workmen's Compensation Act, Your Lordship. It's well established that the for any injury for compensation to be claimed, the injury should have occurred during the course of the employment, Your Lordship, and out of the course of the employment, Your Lordship. For that purpose, Your Lordship, the interpretation of the said term. The interpretation of the said term has already been decided by the Supreme Court. I would like to draw your attention to the case, Your Lordship. The 1969 Supreme Court cases, Your Lordship. However, just for the interpretation of the term, Your Lordship, during the course of employment and out of the course of the employment. Your Lordship may kindly see para number 5, Your Lordship. I have a copy of the pen.
We have one.
Your Lordship, may I be permitted to read, Your Lordship?
Yeah.
To come within the act, the injury by accident must arise both out of and in the course of employment. The words in the course of the employment mean in the course of the work which the workman is employed to do and which is incidental to it. The words arising out of employment are understood to mean that during the course of the employment, injury has resulted from some risk incidental to the duties of the service, which unless engaged in the duty owing to the master, it is reasonable to believe the workman would not otherwise have suffered. In other words, there must be a causal relationship between the accident and the employment. The expression arising out of employment is again not confined to the mere nature of employment. The expression applies to the employment as such, to its nature, its conditions, its obligations, and its incidents. If by reason of any of those factors the workman is brought within the zone of special danger, the injury would be one which arises out of the employment, Your Lordship. Therefore, there has to be a causal nexus between the accident and the work that he was assigned to do, Your Lordship. It is not his case that during the operation of the lift or escalator, the accident has occurred. He also admits that the accident occurred due to his slip and fall. However, Your Lordship, the learned tribunal applied the concept of notional time, extension of notional time and space, and held that the respondent is the accident had occurred during the course of employment, Your Lordship. My next submission is, Your Lordship, assuming that the sorry, Your Lordship. Assuming that the injury had caused during the course of employment, Your Lordship, the the question remains whether the appellant is liable to pay compensation or not under the Compensation Act, Your Lordship. So, Your Lordship may kindly see the page number 5 of the CMA, Your Lordship. In the bottom, Your Lordship, the injury has been specified, Your Lordship. The injury sustained by the respondent. It's an intercraniatric fracture in left femur, and surgery was conducted. An open reduction internal fixation with dynamic hip screw and plate was inserted and fixed, and so, Your Lordship. Your Lordship may kindly see under section 41C of the 41C of the Compensation Act, Your Lordship, the injuries that are not specified in the schedule to the Act, for those injuries, compensation is to be determined Your Lordship. In the case of an injury not specified in Schedule 1, such percentage of compensation payable in the case of permanent total disablement as is proportionate to the loss of earning capacity, Your Lordship. Therefore, it's a well-established principle of law, Your Lordship, that the physical disability does not necessarily lead to loss of earning capacity. The loss of earning capacity, Your Lordship. These two are two different issues, Your Lordship. The respondent has examined the doctor, Your Lordship, put forth the disability certificate, which is page number 11, Your Lordship. Page number 11. The penultimate para, Your Lordship. Dr. V.K.V. Prasad, orthopedic surgeon in Gandhi Hospital, was examined as AW2. Yes. He was the doctor who examined the respondent much after the accident, Your Lordship. However, he issued the disability certificate, and he stated that the appellant suffered from permanent partial disability of about 25%, Your Lordship. However, Your Lordship, whether the physical disability caused to him, assuming that the physical disability was caused to him, whether that actually caused his loss of his earning capacity is a question that needs to be answered, Your Lordship. Lordship, I would like to submit another case for that. Lordship may kindly see para 17, Your Lordship. Before going to this case, Your Lordship, I would just like to state that a medical professional, a doctor, a medical professional can only assess with respect to the physical disability, Your Lordship. When it comes to earning capacity, the court has to decide whether that particular physical disability has led to loss of earning capacity based on the evidence given to or material submitted, Your Lordship. Your Lordship may kindly see para number 17, Your Lordship. I may be permitted to read, Your Lordship, where the Commissioner has to deal with cases of permanent partial disablement inflicted by injuries which are not scheduled. The provisions of Section 41C2 of the Act are attracted. The commissioner has to assess the compensation in terms of those provisions. In assessing the compensation in such cases, the most important and paramount thing that the commissioner has to consider is the loss of earning capacity. He has to consider the nature of work that a workman has to do, the nature of the injury, and other environmental circumstances. The principles upon which the loss of earning capacity under section 41C2 have to be determined are: loss of physical capacity is not coextensive with loss of earning capacity. Second, loss of earning capacity is not coextensive with loss of physical capacity. There may be cases where even the loss of physical capacity may be of such nature as to make it abundantly clear that there has been large, if not complete, loss of earning capacity, even though there has been no immediate reduction in wages. Medical evidence by itself is not conclusive or decisive factor in the loss of earning capacity. It can only establish the nature of disablement or the physical injury. But to what extent the physical disablement causes loss of earning capacity is not for medical evidence to state. It is for the commissioner to settle in case of dispute between the parties, and such settlement can only take place upon the basis that there has been a loss of earning capacity caused by the said injury, and the estimate that should be made of such loss of earning capacity should be proportionate to the loss of earning capacity caused by the injury, Your Lordship. Your Lordship, my respectful submission is that the assuming that his physical disability was caused, it did not lead to loss of his earning capacity for the fact, Your Lordship, because the respondent, for the medical treatment and all the medical bills, the appellant paid for the treatment and bills, Your Lordship. On top of it, the respondent came back from leave. The leave was fully paid. He came back from leave. He resumed his duties. He was able to effectively perform his duties, got promoted within the organization and superannuated, Your Lordship, with full benefits and no reduction of pay at any point of time, Your Lordship.
See, opposite party has not filed any document to show that the medical reimbursement is there. Is there any medical reimbursement? And have you filed the relevant documents to prove that the amounts have been paid?
Your
Medical
Lordship,
expenses.
I apologize that there are no documents along with the.
No. They are not marked, Amma. See the appendix of evidence. See the list of documents filed by the respondents opposite party. R1 to R5 were filed by the opposite party. Except filing list of cases filed by the applicant, payslip, terms of absorption, power related to law department of the opposite party, photographs of the escalated.
Your Lordship, with respect to medical expenses, I have to verify, Your Lordship. But with respect to treatment at the time of accident, Your Lordship, that's an admitted fact, Your Lordship. It's been recorded in the lower court's order also, Your Lordship.
And those amounts are not awarded, no?
They're awarded, Your Lordship. The appellant itself.
Despite admitting.
During the admission process, only appellant paid the for the treatment, Your Lordship. For the surgery.
Where is it, Amma?
Yes.
Where is it? We have the record. We'll call for the record in the meantime. We'll see the evidence of the respondents also. Respondents and cross-examination of the applicant. Whether they have admitted or not.
Okay.
Other side counsel is not available, so no representation for the respondent on call. Counsel for the appellant is present. Register is directed to call for the record immediately from the consent court. Posted to 2811.
Obliged.
If you have the copies, certified copies of the cross-examination documents, you can file on that day, 2811.
I'll verify.
Otherwise, we'll call for the record.
I'll verify.
Yes, Satyamangala Garu is online.
Yes, Lordship.
You're ready with the arguments?
It is a delay of 14 days.
Delay condition. No. No answer pending. It is already posted under the caption for final hearing.
Yes, madam. I am ready. Only this is
We are under the impression that delay condition. Are you ready with the argument?
Yes, Milord.
Okay, proceed.
Only this case will be the petitioner appellate, Milord. This is only we have filed the workman compensation, Milord. Only procedural aspect this was dismissed, Milord. The lower court, Commissioner for Workmen Compensation dismissed this petition on the ground that go for motor company, go last year, motor vehicle act, tribunal. Page number 6. Page number 6. Only we are seeking this one. Page number 6, last minute. The applicants are advised to buy a claim by compensation against the opposite parties. Claims scheme.
Why only at?
This was a fatal accident, Milord.
This
is died due to he was the driver of the tractor and it was untrained and received grievous injuries to his head. Immediately he was died. And they filed the under the Workman Compensation Act against the insurance and owner of the vehicle.
Why employer-employer relationship is not established or what?
Yes, Milord. Because in this case, Milord, in generally, villages are somewhere else. The drivers of the tractors, there is no specific appointment letters and all these things.
Need not.
Owner of the
Need not. If the owner came into the witness box, or at least filed a written statement. He remained ex parte.
Yes, ma'am.
Remained ex parte.
One submission, Milord.
Yeah.
Here, as of date and the incident not disputed, Milord. Only disputed is that the order of the workman compensation stating that go for the tribunal. I pray this, Milord. He is also working under the respondent, third respondent. Under the direction, he was drove this vehicle. And it was a contractile and received injuries and died. Consider it, Milord, my submission, Milord. Consider this application or otherwise directed to the same limitation to.
It will take some more years. This accident occurred in the year 2007.
Yes, Milord.
When will render justice? You tell me.
Milord, here, one submission, Milord.
Yeah.
Cause of death is not disputed.
Yes.
And other one is he was the direction of the owner. He was drove this vehicle and third title and
I will see the FIR and other documents. We have the record. Let me see the FIR.
I filed the final report, Milord. Page number.
Actually, what happened was at the time of accident, he is walking on the road.
Yes, Millard. Page number 10, Millard. After
One
investigation,
minute. I've seen the inquest report, and this is postmortem PMA report. It's an accidental death mechanism. Final report. Factor of health instruments. In final report, it is stated that
page number 10, Millard. Final.
no. In final report, it is stated that LW1 working as driver on the tractor of
That
LW8.
is the husband of
LW8.
PM
And
report also there.
LW8 belong tractor number contract. This is Ventino's tractor convention. Yes. The relatives of the deceased created a story along with LW426 and filed a false petition before the police. Last but 4 lines in the final.
One submission, Millard. Again, continuously. Actually, the deceased himself to drove the crime vehicle at the time of incident. Conducted autopsy over the dead body of the deceased. Issued a PM examination report when that the cause of death is due to the ATD.
And the tractor belongs to K. Tirupati Reddy. Tirupati Reddy.
Yes, Millard.
Is the owner of the tractor.
This is
AP15 U 2663. Yes. Tractor and trailer.
Trailer. Yes, Millard.
Yes. Is having a valid driving license also. Whether the policy is in force as on the date of accident. Exhibit. Insurance policies exhibit A7. Exhibit A7. Page number 37.
Period of insurance 312 2005.
Okay. 535293. Yes. Policy is in force as on the date of accident. Yes, Sachimanjula garu.
Lordship, the matter is very clear that the tribunal has clearly, and the workman commissioner has given a finding that as per the final report, the investigation officer says that it is clearly evident that the deceased died in the course of employment and the appellants are entitled to get a compensation. But whereas in the clearly LW 426, they try to falsely implicate the vehicle and the deceased is alleged to be a workman. Instead of going for a motor vehicle act and filing a OP case, they filed workman compensation, which is in fact not valid and sustainable. That is the reason how the commissioner has dismissed lordship. That is the only point.
See, that criminal record cannot bind on these cases. That I cannot go into. Actually, see, why I have seen the final report is whether the in the charge sheet it is mentioned Is there any relationship with the owner as an employee or not? It is admitted. There is no dispute that he is working under opposite party one as per the record. As per the
I
record.
live your lordship totally.
But giving advice to file an application under MV Act, I do not think it's not correct. They can choose whether to file under Workmen Compensation Act or under MV Act. That is for the petitioners to decide. Without going into the minutes, the tribunal has simply stated the case has to be filed before the MV Act. We'll take a
I live your lordship.
okay.
But one humble request, lordship, in
Yes.
regard to that, when there is no clarity by the tribunal in regard to why it should be filed only on the MV Act and why not
I
in a
will-
WC, that may be given.
I will discuss in my judgment.
Much
Right.
Satyamanjala garu.
Lordship.
Appeal is allowed.
Yes, Lordship. What is the
3
Our
lakhs. 3 lakhs. 56 order.
much of it?
Next. Yes.
I'm for the appellant, my lord. Matter is against the railways, my lord. So, this name may be printed, my lord. The last citizen also informed the same, my lord.
Of the presidential in the case Rajiv Reddy. Rajiv Reddy is constable respondent. The name Badi present. Deputy solicitor number is already, sorry, his name is already printed.
The last citizen.
765, Anna, yes. It's not printed actually. We gave directions, but they have not printed. So, Mali remember, despite they giving directions, they are not at all saying. But Manoj is already to remove the name of Rajiv Reddy, council correspondent. Gadi Praveen by Tamara. $765. Then why Gadi Praveen? On 1923, counsel for the appellant represented to put up the name of Sri Gadi Praveen Kumar, Deputy Solicitor General, as the counsel respondent 1 and 2. 1 and 2, sir. Sir, Mali 1 and 2 already everything is certified. ML already 53. Registry is directed to despite directions, the registry has not printed the name of Sri Gadi Praveen Kumar, Deputy Solicitor General of India, as counsel for the response 1 and 2. Therefore, print the name of so-and-so as 1 and 2. Counsel for the appellant is present. You are requesting time?
1 time.
Arbitration Act. At request of the counsel for the appellant, posted to 7, 8, 12.
Well, 35.
In representation, maybe for more of the respondent. No representation for the appellant on call. No representation on, even on. Even on 12/7/23, 24/8/23, 11/9/23, 22/9/23, 10/5/23. Wait. On 22/9/23, and there is no representation on 5/6/23 also. 5/6/23. Hence, as the cases of the year 2011, it is posted under the caption for dismissal. Column 20, 21.
May I please your lordship?
Yes.
There's a insurance company appeal, my lord. And the case of injuries. The petitioner herein has sustained the injuries while driving a jeep under the employment, as he claims, and while driving in the opposite direction, he saw some buffaloes coming in the opposite direction in avoid to collision with the animal. So he drove the jeep fastly and applied suddenly brakes, as a result of which the jeep turned turtle and he broke his right leg. He sustained the fracture on the right leg and sustained other injuries, my lord, grievous injuries all over his body. This is the nature of accident, my lord, is committed, and in which the employer also appeared as a R1 and he has admitted the employment, and he says he is denied that he is paying a monthly salaries up to 2,500 plus 50 rupees per day in his counter. He has admitted, employer. Now, he date of accident is 2/10/1996, Miller, and date of admission in the hospital is 8/10/1996. After a gap of 1 week, he is admitted into the government hospital. And on 9/10/1996, doctors operated and amputated his right leg, and he was treated in a government headquarters hospital. What happened during the date of accident till the date of amputation, nothing is on record. And he further stated petitioner that he's incurred 1 lakh rupees towards the treatment, medicines, and extra nourishment.
What else? So we have record.
The last occasion, the Honorable Court sought to get the lower court record.
Why? You have not adduced any kind of evidence, either oral or documented.
No, I have yes, yes, ma'am. In the lower court,
Has not adduced either oral or documentary evidence, but
No.
before the appeal.
yes, yes, ma'am. I filed only the driving license in the lower court. Nothing else.
So they have not adduced any evidence. Let us assume for a moment. What prevented the insurance company to adduce? Moreover, appeal has been filed. There should be at least some reasonable grounds for filing the appeal.
Yes, my lord. I have.
And the amount is only
Ground.
51,000.
Substantive question of law, the second ground I raised.
Yes, what is that?
Look, the earning capacity is assessed at the 50%. It should have been taken at 50%, whereas the commissioner has taken 100%. That is against the Schedule 1, Part 2 in the list of injuries. The loss of earning capacity should be assessed at 50%. Whereas he has taken 100%.
See, the applicant is a driver.
Driver.
He has sustained such kind of injuries which he cannot even attend his regular duty like
Yes,
he
physical
cannot
disability.
work as a driver.
Yes.
Teacher also.
Leg was amputated.
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 Yes.
And physical disability was assessed at 80%.
80%.
But it should have been assessed at 50%.
You are not the doctor.
No, I'm not the doctor, but as per the statute, schedule injuries.
See, doctor has physically examined him and assessed the disability at 80%.
Disability, there is no
Based on that only the earning capacity will be decided.
capacity as per the statute is the Schedule 1 injury. It is specified at the 50% has to be taken. Earning capacity.
Not in all cases, counsel. See, we have to consider the profession of the injured also.
Yes, ma'am. It is a schedule injury.
Similar kind of injury sustained by any other professional people, like if a person sits in an office and works, amputation of leg doesn't give a much inconvenience for him. He can attend his regular work.
Yes.
But it is for the driver.
Yes, I understand. The profession is different.
He cannot do his profession.
But the statute provides like this.
That is the reason. It depends upon the facts and circumstances of each case. There are number of apex court judgments available. It's not my opinion alone.
Yes.
Based on the apex court judgment only I'm speaking.
Yes, yes.
Yes, counsel.
Here is one of the judgments as such, my lord.
Yes.
it is stated in the judgment as well that when the disability is the earning capacity is not directly related to partial disability, my lord. When the person is unable to do his employment, like which is currently employed due to the incident, Supreme Court has reiterated that multiple times, saying that it becomes 100% functional disability.
That is what I'm saying.
cases.
While considering the percentage of disability as per Exhibit A disability certificate, the age was taken as 29 years. When they are recording the age as 32 years, the factor that matters.
My lord,
The age recorded is as 32 years.
but that record was given after 3 years from the incident, so it was already considered in that file.
Sorry to interrupt, Mila.
I will put it in the discussion, your contention also.
Yes.
I'll put it in the discussion, but the petition has been filed after 3 years after the accident. So obviously his age will be more than the age on the date of accident.
Date of the accident.
Obviously. Next.
Sorry to interrupt. Item 35, my lord, I was held up in another voting. I'm for respondent, my lord. NG.
You're for the respondent,
Yes.
yeah? Anyway, I have adjourned the matter under the caption for dismissal because counsel for the appellant is not turning up.
Obliged.
It has not appeared.
Obliged.
Okay. Claimant. To remove the Sambasura garu? Okay, okay. Reddy garu representing CV Bhaskar Reddy record and submitted his intent to file Wakala for the response. No, in the last occasion, C. Reddy garu represented that he is going to file Wakalat on behalf of respondents 1 and 2. Already has stated. We'll see if he doesn't file Wakalat, then no representation for the appellant on court. Hence posted to 2012 matter. Samsuragara, okay. At request of the counsel for the appellant posted to 612.
Your Lordship, senior is an online.
Your serious
yes.
online, Amma.
Yes, Your Lordship. Connected matters, Your Lordship. List of connected matters.
There are connected CMAs, my lord, 142 to 155.
Okay.
They are all connected, my lord. In all these cases, my lord, LR applications are filed.
Okay.
This is also a case of eviction, my lord, and the appellant was directed to be ordered to be removed, my lord, for encroachment. I think it has to be posted for once when the LR is ordered, my lord, it has to be heard, my lord.
Register is directed to list our numbers along with CMA 142 of 2012.
Yes.
And you are representing?
R2 minute.
Sudarshan Reddy class. Counsel for appellant GP for arbitration R2 are present and posted.
Right. There are 2 cases are posted on 23rd. Same also may be posted, and that day Millard will verify what are the cases LR petitions are pending. Once Millard all are the order, will post for one.
My lord, in that case, probably in one case, my lord, that is already ordered. These cases, LRs are to be ordered.
Anyway, we'll verify on 23. I'm posting on 23/11. All the cases will be posted on the same date. 23/11.
My lord, 23/11, I have some personal inconvenience because marriages are there on 23 and 24. Some other day.
Your junior will be from that day. Legends, don't worry. Next, is this connected? This one?
No, you Lordship,
39.
it is not connected.
39 is a different
matter.
That's a different matter.
Okay. 39. GP for arbitration. 39. Item number 39. Give the file.
My lord, 39 also, my lord, I'm sorry. 39 also is a case connected to.
No. That is different district and different temple.
That particular petition is the order of a dismissal by the endowment tribunal, wherein, my lord, I filed an application under section 87 of the Endowments Act seeking a declaration that it's not a public religious endowment. my lord, that was dismissed, against which, my lord, the present say civil miscellaneous appeal is filed under section 88. My lord, in this case also, my lord, probably this coming for the first time, I think your lordships may have to call for the records.
Okay. Okay. We have received the record, sir.
Yes, my lord. GP for arbitration, if it's ready.
Yes, my lord. That's my post after 3 or 4 weeks, my lord, we'll do it.
GP for arbitration always requesting time after elections.
Because the whole matters, my lord, we are totally helpless, my lord.
Okay.
Because probably the bundles are not being traced. That was what is the complaint.
Yes. In the last occasion also.
Yes.
Represented the same. Anyway, a counsel for the appellant and GP for arbitration are present. At request of the GP for arbitration posted to how many days you need?
3 weeks, my lord.
3 weeks. I'll post it in December only. 8/12.
Obliged. Batch.
Naresh Vairapuneni Satya Manjula garu is there? Yeah. No representation for the appellant. 1 or 2. 2 times. No representation for the appellant and for hearing posted finally on 21/11. 21/11 finally. No representation on either side. Are intent to engage the service of new counsel in the same time. No representation either side and call and posted to. Last occasion they said they are changing the counsel, but no wakalat is filed till today. Posted 8/11, 8/12, 8/12.
Appearing for the respondent, my lord. Appearing on behalf of Kota Samir Kumar, my lord, for the appellants, my lord. My lord, senior counsel is out of station. Matter may be posted after 2 weeks, my lord. On this simple ground that as the employer and employee is a father and son. That is the only ground. There is no bar in the working competition.
You are representing the respondent or
Appellants,
Kota Samir Kumar. Kota Subaragara. Kota Samir Kumar.
Samir Kumar.
This is the first time I think has been listed in this court. First time it is listed. We'll give an opportunity. Both counsel are present at request of the counsel for the appellant posted to 8/12.
8/11.
8/12.
May it please the lordships, I am appearing for the appellant, my lord.
Yes, Ramil garu.
It's a case of death, my lord. Claim is 5 lakhs. Awarded amount is 4,73,804. But the workman is a driver and the tractor trailer. The appeal is filed on the ground that the deceased did not possess the valid driving license. In this case, my lord, the owner appeared and filed the counter, but did not enter into the witness box. Similarly, insurance company filed the counter, but did not enter into the witness box. the employer had admitted the employer relationship and everything, but in regard to driving license, he did not speak anything else. The finding is, commissioner's finding is, nobody expects that a old man and wife can file the driving license of the deceased. Therefore, rejected our contention. That your lordship would get it. Fifth page, my lord, impugned order, fifth page. As for the driving license of the deceased workman, how can the wife and old parents of the deceased workman, late Balraju, be legitimately expected to file it before any authority? They are not legally bound to keep it in their custody. One can understand if such insistence is made in respect of non-fatal cases. This is the reason our contention was rejected. Even though the employer, neither employer nor insurance company entered into the witness box. That is, no evidence is adduced by the insurance company, also the employer. So then I leave it to your lordship.
KLN
In
Rao.
all these cases, my lord, in all these cases with regard to driving license, yes, at least they have to provide something. Otherwise, the insurance company is impossible to trace out the license and get it filed before the court. Something, my lord, something. Owner has to say something else. Owner has to file it, or the dependents are to file it. But nobody. Owner will come say, and the insurance company, the vehicle is insured, insurer will indemnify the compensation. Therefore, he doesn't bother about thing. And dependents also the same position. Of course, our insurance company also did not enter into the witness box. At least officer should have said, "Your lordship, I will leave it to your lordship then."
Heard the learned counsel for the appellant. No representation for the respondent. For hearing the respondent. Posted to. I'm putting as part heard. 13, 11.
13th, my lord.
Wait, sorry. 1611.
16.
1611. For hearing the respondent. After hearing the respondent, I'll dispose of it.
Because the appellant, my lord, again, this problem will come. Mr. KLN Rao, he is no more.
Oh, no.
KLN Rao is no more. He passed away long back.
Then I'll dispose of the case.
Your lordship may dispose of that. Yes, to dispose of the matter.
Instead of putting it.
Yes. Same manner, no evidence is adduced by both the parties, and therefore your lordship confirm the order.
Okay.
Interest was also awarded. Interest was also awarded.
Okay.
After all, death case, driver death case.
Eight 48 of 2013 appeal is dismissed.
Obliged.
I am appearing on behalf of the respondent counsel.
Mm.
Lordship may have this matter after 2 weeks. There's some personal inconvenience for the respondent.
Anyway, it has been listed after a long time. After 2013, now, after 10 years, we'll give an opportunity. No representation for the appellant uncle, counsel for the respondent is present. As posted to 12th December, 12.
I am appearing online, Lordships, in this matter for the appellant.
Mm.
They have filed counter, Lordships. They have served the copy on me yesterday. We will be filing our reply. Lordship may post it after 2 weeks.
Is this the procedure? Mm, 938. No, 938 only. 938. No, I'm asking about the proceeding sheet. This matter is listed after 2013.
First time.
See, from 2013, this file has not seen the day of light. Only today it came.
Yes, ma'am.
Okay.
Yes,
It has been listed after a long time. We'll adjourn. Counsel for the appellant.
Not being listed, we have filed counter yesterday, my lord. They have also filed an IA in the other suit, my lord, in which was dismissed, wherein we have sought for impediment of the petitioner as one of the respondent. There, that petition has been dismissed before the lower tribunal, lower court. Against that, we have filed CRP. Along with that, my lord, it has come to our knowledge that no counter is filed in this. We have filed counter yesterday. That's all, my
The
lord.
counter is also not on record.
Yes, madam.
Counsel for the appellant appeared through hybrid mode, and GP for arbitration is present. As the matter is listed after 10 years, this is rather after 10 years. No, it is adjourned to 11/12.
Obliged, Lordships.
Obliged.
No representation, first time, huh? All these matters have been listed for the first time after 10 or 15 years. No representation either side on call, hence posted to 12/12. No representation. Neither side 12. Ramakrishna Reddy garu, just now I have adjourned the matter. 46. Are you ready? Because the other side is also not available. I posted to long date 12. Yes, item number 48. Muhammad Ryan. No. Representation. These matters have been listed for the first time after many years. No representation. But the appellate posted to 11/12. Next. Mahendra Reddy garu is online.
Yes. This matter, my lord, connected matter 515 of 2023 came before another judge, my lord, another roster. This final matter came here, my lord. I earlier also pointed out the same because the fresh number given, it is not a different roster. I request your lordship, my lord, 546 of 2015 will be heard together, both the matters. The lordship may seek permission from the CJ so that both matters can be heard together, my lord, either before this bench or another bench.
What is that number, sir? Furnish that number.
CMA 559 of 2023, my lord.
559 of 2023.
Yes, my lord.
Finish.
In this matter, there is a delay. I have said no objection. Delay was condoned also, my lord.
Okay. There is another matter is posted in another court. And the court, therefore, registry is directed to put place before the Honorable Chief Justice to transfer either 546 of 2015 to another court or Anko court, to this court. 559 to this court.
Much obliged.
We will not give dates. It will be placed before the Honorable Chief Justice.
Yes, ma'am.
Next.
Lordship,
Yes.
Your Lordship, the council is out of station, Your Lordship. We have it
Mm.
after 1 week.
Counsel for the
petitioner, Your Lordship.
counsel for the appellant.
Yes, Your Lordship.
Counsel for the appellant appeared to watchful note. Counsel for the respondent is present. At request of the counsel for the appellant posted to 6/12.
Much obliged, Your Lordship.
I'm appearing with first respondent, Lordship.
Okay. Satish Reddy garu. No representation for the appellant on call. Counsel for the respondent appeared to watchful now. It's posted. How many adjournments they have taken, Satish Reddy garu? In the presidential. First time. Okay. Posted to 7/12.
Much obliged.
Records are there? Both counsel are present. Registry is directed to call for the records from the concerned court immediately. Posted to 30.
We are filing the appeals against it. That is it. But here is case. They filed the appeal. The case against them is dismissed. Non-proving of employment. Most of the way will come. Case of this nature.
No, what happened? This is WC is dismissed.
Dismissed.
I think they are the applicants. They have preferred the appeal.
Well, we are coming. Appeals, but it's surprisingly they have filed.
Yes. 30/11.
30th.
30th 11. We'll see whether we'll get the records or not.
30th of this month.
This month.
The appellant insurance company, Lordship, on this matter, records are.
We have not received records. So shall we call for the records?
Yes, Your Lordship.
Okay, both counsel. Okay, both counsel are present. Registry is directed to call for the records from the concerned court immediately posted to 1st December 112.
1st of December.
1st December.
Okay.
Obliged.
Anjali Agarwal.
Lordship, I am representing some.
Present.
Lordship, kindly have it after 2 weeks.
Why after 2 weeks?
Female is not feeling well, Lordship. She has some throat infection.
In the records section. Anyway, he is giving.
We'll give the record.
But she is the junior counsel, I think. She can't.
Only one point. What happened, Milad? A 70-year-old person was traveling from Secunderabad to Peddana with a journey ticket. He accidentally fallen down in the middle of the way. So,
Journey
court
ticket
did not decide the issue number 1 and 3, untoward incident and journey ticket. Dismissed the claim petition on the sole ground that the aged sons are not a dependent.
Okay, I will.
Aged sometime daughter are not dependent. But then
She's not there. When, Amma? Not 2 weeks. This they're all. Both counsel are present at request of the counsel for the respondent posted. You furnish relevant judgments also. Relevant judgments on that day. I'll adjourn the matter. I'll post it on 2011. Okay. Get ready. Relevant case laws if furnish. Yes, next. First time. No representation for the appellant and call. Hence posted to 12/12. Yes, Sampada. Madam, Sampada.
Yeah. Milord, my voice is audible, Milord.
Yes, your voice is audible, though your video is not clear.
Milord, it's coming for the first time, Milord.
Okay. And notices are already
Yes,
served.
notices are served, Milord. Nobody is representing there.
Yes.
Maybe taken up after 2 weeks, Milord.
If the other side is not there, no, you can proceed with the arguments. Sampada.
Milord, after 2 weeks, Milord. Just now.
Counsel for the appellant appeared through virtual mode. No representation for the respondent. At request of the counsel for the appellant posted to 28.
Obliged, Milord.
In this matter, I am appealing for the response.
I'm for the appellants, Your Lordship. Kindly have this after 2 weeks. We want to file a booklet. There are around 600 pages, so we'd like to file a booklet. So kindly have it after 2 weeks.
There was a kind of next week, Milord, this is there is urgency in this matter. Already this is a partition suit. Final decree was passed and possession also I handed over. So now
Final decree is passed.
Final decree is passed, Milord. In the year 2018 itself, final decree was passed. Possession was also handed over.
Then why they have preferred the appeal?
Your Ladyship, the appeal was filed in 2000.
Let me see the judgment. Judgment. On what grounds this appeal is preferred?
Without making the subsequent purchases, that main contest before the appeal is not before this honorable court, without making the parties the subsequent purchases. The vendor is the party before the lower court. So the main contention is without making the subsequent purchases, they filed the partition suit. That is the only contention. Their vendor is the party. Moreover, they have not submitted any document before the honorable lower court. Their vendor's document.
Only two questions.
The honorable lower court granted the equal shares to the appellants and the respondents.
Share to the plaintiff, other share to the defendants.
Your Ladyship,
You are the defendants or plaintiffs in the suit?
They are the defendants.
You are defendant. You also got share, equal share.
There are
Par with the plaintiffs.
There are few more contentions, Your Ladyship. Even next week's time, we just want to file a booklet before the argument happens. Because there's 600 pages of
Finally,
papers, so we want to file a booklet.
Already.
How many days? Give me the proceedings. How many adjournments they have taken?
There is honorable chief justice notice also there.
Notice on this. Based on that note only, a case has been transferred to this court. First time it has been listed before this court?
Before this court is first.
Okay, both counsel are present. At request of the counsel for the appellant. Posted to
1 week.
2019 matter, sir.
18 and 19.
Yes, 18 and 19.
And
even if we insist also, I do not think. Who is your senior, Amma?
Belgapuri also.
2411. Get ready.
Finally.
First time it has been listed. Yes. Let us hope his senior also. Her senior will get next. Next. 3 matters are connected, huh? 3?
2 matters.
Only 2.
The third one is also Srinivas. Well,
yes.
It's a different case.
It's a different case. It's a different case. In item number 59, Your Ladyship, kindly order fresh notice for respond number 3 and 5. For respond number 6, Wakalat has been filed.
We are representing for respond number 6 in the last occasion itself. Fresh notice was issued, my lords.
But it is been, yes, in another court, not before this court. However, notice has been issued, fresh notice, and personal notice is also permitted. And you are not filed any proof of service, Amma. On 27/9/23, fresh notice has been issued, and personal notice is also permitted.
Okay.
For respondent number 3 and 5. 3 and 5.
Kindly grant 1 week, we'll issue personal notice system.
It is already there. Need not issue fresh notice again. So, both counsel are present. At request of the counsel for the appellant. For filing proof of service posted to, because you have to issue notice whether you have issued or not.
I will get instruction and we'll file the proof.
Based on that, I have to give date.
1
If
week.
it is fresh notice, no. If you have not issued notice, I have to give a longer date. Otherwise, if it is only a personal notice, at 1 week or 2 weeks is sufficient.
If you could grant.
Anyway, it is 2019 matter. I am adjourning it to 4/12.
Obliged.
Yes. Step check. Is now coming to item number 64. 64 special identified cases. No, you know why these cases have been listed. Actually, in these kind of cases, we have verified online and found that the appeals, the suits are already disposed of.
Well, it's just to find out what has the prior instructions regarding this matter.
I'll give you only 1 week time, Amma. You have to verify and tell because nothing survives in these kind of cases because already the main suits have been disposed of. We have identified those cases and have been listed. Okay. Just find out and posting it to 17. Only 1 week time I'm giving. Just find out and 17/11. Next.
And for the appellant, my lord, the matter in the lower court was uncontested, my lord.
Yes, in the morning,
parties
council has represented.
Yes, ma'am. The CMA becomes
Yes, it is dismissed as infructuous.
Oh, pleasure.
Yes, my lord. The suit has been dismissed long back on 36/2022
Which one, sir?
in item number 66.
66. Katta
It
Lakshmi
has been
Prasad Garu.
dismissed on 36/2022, my lord. The arbitration award also has been passed. Nothing remains in this case. It has to be dismissed as infructuous.
Yes, this one also 66 is dismissed as infructuous. Yes, next. Next.
68. And for the respondent, Your Lordship, the suit is still pending before the trial court, Your Lordship.
This also, it will become.
Suit is pending, Your Lordship.
Pending.
Pending, Your Lordship.
Pending.
Initially, that was dismissed for default. Lately, that's a restored, Your Lordship. And for the respondent, number 1.
Counsel for the respondent is present. No representation present. Appellant on call was posted to 2018 matter. 5th December. 5/2.
Develop the stage.
The counsel for the respondent represented that the matter has been restored to its original shape. Hence removed from the special list of special identified cases. ಅದೆಲ್ಲ ಮುಂಚೆ ಒಳ್ಳೆ you.